All right, so we're going to dive down a little bit deeper into what can be covered by copyright law. We have the three categories. We have the original works of authorship, creative expression, and derivative works. And we have some examples of those. So the very heart of the copyright law is the aspiring writer or the original work of authorship. So they have to have, an element of creativity with them. They can't just be regurgitated from something else. That's plagiarism. So you have examples of some original works. For example, the novel by J.K. Rowling, let's say Harry Potter, or an original story by any other aspiring author would be considered an original work of authorship. Music, we're talking about an original song, including the lyrics and the melody written by a musician. Art would be the painting created by an artist that wasn't copied from an existing work. That's important. Wasn't copied from an existing work. Where's that AI fall in there? And that's where, the copyright on art, gets a little hairy whenever you start incorporating AI. Software, a unique code of a computer program created by a developer. A film, so a movie screenplay or the actual recorded film itself. Either of those are covered by copyright. So these works are protected as soon as they are fixed in a tangible medium, meaning they are written down, recorded, or saved in a physical digital form. The copyright holder has those exclusive rights to reproduce, distribute, display, and perform the work, as well as create derivative works based on the original. All right, so second category is creative expression. So copyright law does not protect the ideas, concepts, facts, or systems themselves, only the way in which they are expressed. So, this protection of the creative expression allows authors and creators they have control over the specific way of communicating ideas, but it does not prevent others from expressing the same idea in a different way. So, for example, let's see, examples of creative expression. A news article. The facts reported in the news article may not be copywritten, but a specific wording and structure chosen by the journalists are. So there could be two different articles covering the same event, but only the expression of that content is protected, not the subject. That kind of makes a lot more sense. So a painting. Here's another example. A subject of a painting, like a landscape or historical event, is not protected. However, the unique artistic style, color choices, and composition the artist uses to portray that subject are protected. Another example of dance choreography, the dance steps themselves, when arranged in a fixed and original way, are protected as a form of creative expression. The idea of a dance routine or concept of dance styles, however, are not. And so creative expression protection prevents others from copying the precise way a creator expresses their idea, but does not prevent others from conveying similar ideas in their own style or manner. I could see where that could get a little gray from time to time, but something to consider. Derivative work is a new original creation that is based on a derivative from one or more existing works. For a derivative work to be protected, it must incorporate significant original expression, even though it's built on an already existing copyrighted work. Derivative works can include adaptations, translations, or expansions of original works. So here are some examples. A movie adaptation of a book. When a movie is made from a novel, the screenplay, directing, and acting bring new creative elements, making a derivative work. For example, The Harry Potter films are based on J.K. Rowling's novels, but they include original creative contributions such as the actors' performances, cinematography, costumes, and adapted dialogue. So there are new elements to that creation. A translation. So basically, when a book is translated from one language to another, the translator's choice of words and style constitutes new original content, creating a derivative work. So once again, whenever you're translating from one language to a next, sometimes the wording is not always perfect. And so you have to make some minor manipulations to convey the correct message. And that is also protected under copyright. Sequels and prequels. A sequel to a book or a movie, while based on the original characters and storyline, introduces new plots and developments that makes it a derivative work. Parodies. A parody takes an original work and modifies it in a way that adds commentary or humor, and that's creating a distinct work that may qualify as a derivative work. Say may qualify, another gray area that you might run into. And so some of those copyright protections, only the new original elements added to the derivative work are protected under copyright, while the underlying work remains protected by its original holder. For example, someone adapting a public domain novel into a modern screenplay would own the copyright to the screenplay, but not the original public domain novel. So there is a kind of a hard line there on who owns what. So that is, in essence, an example of everything and how you process what is covered by copyright and what isn't covered.